Constitution is not merely a lawyer's document. It is a vehicle of life, and its spirit is the spirit of age. Good morning, distinguished dignitaries, faculty members, and my colleagues. A warm welcome to each and every one of you as we gather on this momentous occasion to celebrate 75 glorious years of our beloved Constitution. It is an honor to be standing before you today as liberty and fraternity which bind us together as a nation and guarantee freedom and dignity to every individual citizen. Without further ado, I would now like to request our principal, Dr. Shabir Ali, to present the welcome address.
Good morning, all of you. Good morning.
Good morning, sir.
So we are gathered here to celebrate and to verify what is happened for our Constitution for the past 75 years. If you read the Constitution of India, it was adopted in the year, which year it was adopted? Almost now 75 years, and they are trying to celebrate 75 years of Indian Constitution. If you read the Constitution of India, when it came into force in the 1950, how many articles are there? How many articles are there beginning of the Constitution? 395. And in 2020, they became 448. And consist of 22 parts. Now there are 25 parts. There are 8 schedules. Added 4 more schedules. Now there are 12 schedules. How many amendments are made till 2024? So 395 articles and almost made 106 amendments till 2024. So if you look at the Indian Constitution, what are the lengthiest Constitution in India earlier? Now other countries beats India and they made lengthiest Constitution. So if you look at the Constitution of India, what are the most important document everyone should know. For any exam, if you go for GPSC, UPSC, or any exams even we can say it made for MTS or the staff, for the most important issues they ask about MCQs is Constitution of India. So everyone should know the Constitution of India and how it's made, what other things. So it is our privilege where DHE sponsored us to conduct the program today, and we are here to celebrate 75 years of Indian Constitution. And before that, let me introduce today's chief guest. On behalf of management, faculty, non-teaching faculty, and students of the college and invitees, it is my proud privilege to introduce today's chief guest, Hon'ble Shri Justice M.S. Karnik, Judge, High Court of Bombay at Goa. Welcome, sir, for this inauguration. My heartfelt welcome for you for this inauguration. Now I request Ms. Arya with a bouquet of flowers to invite to welcome the chief guest of today's program. Sir, I would like to inform our has taken all troubles and faculty members as well as all students have cooperated in introducing theory and practice in order to bridge the gap between theory and practice. So earlier I have seen that it is only theory and practice students are going to learn when they go to court. So college has initiated various activities like legal aid cells, moot courts, we are in clinics, area competitions, guest lectures, mock trials, client counseling. By using all these methods, we are trying to create a gap between theory and practice. And even sometimes our students take the complaints about consumers, they try to prepare the draft and they try to argue before the court, and even they try to do justice for the complainants during their tenure as students. And by this they are learning the skills, research skills, argument skills and other skills. And even colleges take part in all kinds of activities in India as well as abroad, and even our students got laurels in many activities throughout the world. And college is well-known college in India as well abroad because of the activities we are conducting. And I want to mention that ours is the only college in India as well abroad having 27 permanent legal cells. And these cells are running permanently every Saturday And students are members of the cells and they're trying to create awareness and they're trying to help and they're going to provide parallel services to the complainants who comes and approaches the legal cells. So it's one of the most important activities that college is conducting throughout so almost for 27 years. So this is a way the college is trying to inculcate various skills which are required for advocate, which they want to practice. And even if you refer to majority of the students, they go for practice, and only we can say around 20% they may go for higher studies as well as they take part in various Goa Public Service Commission exams and they are achieving various posts from, we can say, after exams. So let me welcome my two colleagues and coordinator of this event, Dr. Sandaram and Dr. Amosharali. Warm welcome to both of them. A heartfelt welcome to Senior Advocate Saresh Lotlikar, my colleagues, and Dr. Carmo D'Souza's family members who are here, my colleagues and faculty members of various departments, and all the students who gathered here for the special guest lecture is going to be delivered by Hon'ble Shri Justice M.S. Karnik. Before winding up, just I want to give who is a lawyer. Daughter informed that I want to marry a lawyer. Then father said, why you want to marry a lawyer? Why you prefer lawyer? Daughter gave few answers. Lawyer bows their head while entering in the room as well as while going out. Bow their heads when they enter the room and when they are going out of the room. Second answer, they say Your Honor or my Lord before every word. So they say Your Honor or my Lord before and after every word. The most important, they don't have male ego. They don't have male ego. They wear gown. Lastly, they go to bar where liquor is not served. Thank you. I don't want to be hurdle between you and the judge who is here today to give his wisdom and knowledge to share his thoughts with us about sacrifice of Indian Constitution. Thank you. Welcome to each and everyone for this session.
Thank you, sir. I now call upon Dr. Amod Sharali to introduce our distinguished chief guest.
A very good morning to one and all present here. It is indeed my privilege and honor to introduce the chief guest for today's special lecture on the role of judiciary in a democracy. Justice Karnik was born on 10th February 1969 at Nasik in Maharashtra. He completed his LLB in 1991 from Pune University, securing first class with distinction, and subsequently enrolled as an advocate at the Bar Council of Maharashtra and Goa on 22nd July 1991. And since then, his lordship practiced at the Bombay High Court and appeared in a number of criminal, civil, labor, service and constitutional matters. Apart from this, his lordship was also amicus curiae in several other matters. His lordship was engaged as a senior counsel, Group 2, to represent the Government of India and also the High Court administration from April 14th, 2009 till his lordship's elevation as a High Court judge. Justice Makarand Subhash Karnik was elevated as additional judge, Bombay High Court on 17th of March 2016. It's a privilege to have him here amongst us today, sir. Thank you for accepting our invitation, and we are eager to hear on a subject which is very curious, the role of judiciary. Thank you so much.
Thank you, sir. I now call upon Dr. Mrunmayi Vaidya to brief us on the book, One Nation, One Law.
Honorable Justice Shri Makarand Subhash Karnik, Judge, High Court of Bombay and Goa, respected Principal Shabir Ali Sir, Dr. Sandhya Ram, Dr. Amol Chirali, respected Senior Advocate Shri Saresh Lotlikar, Senior Advocate Shri Bharne, other dignitaries, staff members, dear students, a pleasant morning to all. On the occasion of celebration of 75 years of the Constitution, I take this opportunity to present before you the book which we have published, One Nation, One Law, Unification of Family Law, which presents the spirit of Article 44. This book has been published in the fond memory of our former late faculty, Dr. Carmo D'Souza, who has rendered long-standing service to this institution. We were very keen on paying tribute to Dr. Carmo for his service and commitment here. And it was precisely at that time that the Law Commission had invited recommendations and suggestions from general public regarding having uniform code in family matters. And in Goa, we already have an operational civil code in family law right from the Portuguese time till date. So we thought that this was a good initiative we could take because there couldn't have probably been a better tribute which we could have paid to Carmo sir. Dr. Carmo's contribution to study of Goa laws and comparative law is immense. Throughout his teaching career and post-retirement, he has been extensively involved in research activities in relation to specific reference to the state of Goa. He published his valuable research in form of several books. In fact, his major contribution in family law was the book Civil Law Studies, India Perspective, which was published by the Cambridge Law Publishers. Dr. Carmo has always been of the opinion that there is a need to extensively research the area of family law, towards which he himself had been relentlessly striving. Carrying forward his mission, we present this book as our contribution in this field. The idea of this book basically is the brainchild of our very own professor, Professor Dr. M.R.K. Prasad. This book contains 13 chapters which are authored by some of our faculty, some faculty from other states, some advocates and other research scholars. And the topics range from the need for uniform civil code, constituent assembly debates and all matters in relation to family law, from marriage, divorce, inheritance, etc. It has been peer reviewed by a team of external experts to whom I am very much obliged. In this endeavor, a profound and special appreciation goes to our librarian, Mr. Nalin Fardesai, who has been actively involved in this publication. I also express gratitude to our publishers, MPP House Bangalore, and I'm very proud to tell that this book is also available on Amazon. Right now, these books are on display at the back of the hall. On this occasion, I also acknowledge the presence of Dr. Carmo's brother, Mr. Hon'ble D'Souza, and his sister, Ms. Talita. I now request Honorable Justice Shri Makarand Karnik to formally release the book, requesting Arya to please hand over the book to the Honorable guest.
Rao sir.
Thank you, sir.
Thank you, ma'am. It is my privilege to now call upon our chief guest, Honorable Shri Justice Makarand Subhash Karnik, to deliver a special lecture on the topic, the role of the judiciary in a democracy. Your Lordship, I request you to proceed to the dais and address an extremely eager audience.
you so much. The principal of this esteemed college, which has completed 50 years, the Salgaocar College of Law, Dr. Shri, the coordinators of this today's event, Dr. Sanjay Ram and Dr. Shri, Shri Lotlikar Sahib, learned senior advocate, Shri Bharne, the lawyers present, the family members of Shri D'Souza, Miss Annalise Fernandez. Well, I must share a little secret that because of the busy schedule, I had asked her to do some work, research on this and help me with the topic. She has done a lot of work today. And most importantly, the staff and the future of our country, the dear law students. There are many from the law clinic, legal aid also present today. The author of today's book release, One Nation, One Law. My dear students, I am really happy to be a part of the celebrations of 75 years of the Constitution of India. Now, before we go into what this 75 years is, there have been various articles written on the role of judiciary in a democracy. So I don't think I should be picking up paragraphs here and there and reading the written script to all of you. But I thought I'll share with you some of my thoughts, some of my experiences. Well, and these are very, very individual experiences which, I don't force anything on anybody, and these are my personal opinions. So therefore, I thought instead of reading a written script, I would just share my experiences with you. Because everybody has a baggage of some experiences, our culture, our family, our friends, everything goes into what a lawyer is, everything goes into what a judge is. So you'll always find two judges different, two lawyers different. So this is what we value, this unity in diversity. Now let me go back to the times, because today we are on a very important topic of maybe delivering justice in a democracy. So we should go back to the times, very old times, when the justice, what was the justice delivery system then? And did this justice delivery system really exist even in the olden times? So as far as I know, as far as I have read, in olden times the justice was delivered by the kings. It was a sole prerogative of the king of the kingdom to deliver justice. Whatever he says was accepted by the subjects. Now, over a period of time, the responsibilities of the king increased, and therefore he started relying on the council of ministers. Now, they started advising the king because he had to look at the warfare, he had to look after the economic affairs of the state, he had to look after so many problems, and then justice was also the most important, it's very dear, it is the soul of any society. So, therefore, he started seeking the advice of council of ministers. Over a period of time, even this council of ministers started focusing more on the administration of the state, because the kingdom increased or whatever, and therefore started the system of maybe delegating this justice dispensation to those who are really experts in this field, and that is how the concept of the court started. Now, so far as India is concerned, why is there a democracy? We were ruled by the Britishers. There have been several invasions in the past. If you go through history, there have been several invasions. And therefore I want, my dear students, we are all students of law here. It's very necessary to understand this concept of justice. Why are we there? Are we here as lawyers to earn money? Are we here as judges to just write judgments? Or what are we here for? These concepts should be very clear in your mind before you take the plunge into the legal world, and therefore I go into all this. Now, therefore, India was ruled for many years by the Britishers. India was invaded by so many invaders, plundered, looted. Everything happened. You know, in the freedom struggle, how freedom fighters fought for the freedom of this country. And ultimately, after years of freedom fighting, struggle, and all the turbulence that the people had to go through, we ultimately got freedom. Now, what we really value is human dignity. And that is precisely what the framers of the Constitution wanted. And the framers of the Constitution felt that we, the people of India, should rule this country. Now let me give you, before I go into this, let me give you one example of what justice really is and what has really inspired me. And that is what was told to me by one of my seniors. This is how you have to always approach a matter or a litigation. Now there was a king who was very, very noble, and he was known to be just and fair. Now Lord Shiva, this is mythology. Now Lord Shiva wanted to test him. So Lord Shiva took the form of a cow and a calf. So the king's son, who was also well trained in the dispensation of justice in warfare, so the king's son was going on his chariot with full speed. The roads were cleared for him, and the calf came in the middle of the road and the chariot ran over him. The calf died. Now Shiva wanted to test the justness of this king, so he goes to the king. The cow goes to the bell. There is a bell outside the palace, and the cow rings the bell. The king comes out and sees a cow, and he's surprised. So she tells him that, it is because of your son that I have lost my child, and please do justice to me now. So the rule is hand for hand, eye for eye, and then it has to be a son for a daughter. So the king says, he takes a very brave decision, bold decision, and says, well, you are right, and my son will have to be run over by a chariot. They say, you are the king, you can take the decisions, who's going to stop you? He said, it's not that. My kingdom is based on justice. My kingdom is based on fairness. That is what the values I have been taught. And therefore, this is the justice I am doing, and will please prepare for the execution of my son. Then of course Lord Shiva comes, he blesses him, all that is, then he comes back to life, the calf goes back. So that is what the concept of justice is all about. Whosoever it is, when you are standing as a lawyer, you stand for your client, you stand for justice. This is what really the justice is all about. Now then another thing which my father-in-law told me when I became a judge, that don't be too very obsessed by writing judgments, long judgments where you have these case laws, pages after pages quoting. With a 10-page judgment, you make it into a 100-page judgment just to show your wiseness, to show how much research you have done. So just stick to the facts of the case. So there he gave me an example. You have papers, you have documents, you have witnesses, you have evidence, but how do you find what is the truth in the matter? Just on the basis of documents, just on the basis of the witnesses, and he gave me an example. Now take a case where, there's a very poor person who finds a small pony, and then he brings it, he feeds him. The pony grows up into a very black, beautiful stallion, muscular stallion, and everybody is in awe of that poor man, but they are constant companions. Now the merchant of that particular village, eyes that he has set his eyes on the horse. Now he says, I'll offer you any amount of money, but please give the horse to me. So he says, no, there's a lot of attachment. He's been with me since childhood, I won't give it to you. So the merchant then, one fine day, he's strong, he's very powerful, just takes the horse away and puts it in his stable. The poor person goes to the king and makes a complaint. The merchant goes to the king and says, I have about 100 witnesses who say the horse has always been with me. Here are the witnesses, just show me one witness who will say that the horse was ever with this man, he's lying. So the king says, well, there are 100 people deposing against you, and the horse says, you flog this poor man. So the poor man is put in the gallows. One of the wise men in the court sees something wrong somewhere. So he decides to do a test and tells the king, sir, this horse belongs to this poor man. He says, what are you doing? What are you saying? 100 witnesses have deposed against him. Everything is against him. And you are teaching me all this. Nobody said, let's put him to test. So the horse is brought to the courtroom. When the horse comes, this wise man tells the merchant to touch the horse, and he asks the poor man to touch the horse. And then king realizes that this horse in fact belongs to this poor man. Because the look in the eyes of the horse says it all. The way the horse reacts to him, and then he says, you flogged this much. This is what justice is all about. You have to go into the core of the issue. And therefore, I always say, don't be very judgment and case law centric. We are too obsessed with case laws. And as students of law, what you have to find out is what are the facts of the case. When you will be dealing with litigants, you will be dealing with clients. Try to get into the skin of the litigant and try to find out what his case is all about. And even as a judge, what we have to see are what are the facts of the case. After we see the facts of the case, we have to zero down on what the conclusion could possibly be. And thereafter we see the law and then apply the case laws which are cited before us. It can't be the converse. Understand the law first and then you apply. This case should never be. This is my personal opinion. I may be wrong on this, but this is how we shape up over a period of time. So therefore, please bear in mind all this. Now coming back to the point where we the people gave ourselves the Constitution of India. Now what is this Constitution and what are we the people? Now when you see the Constitution, our principal has already told you about how many articles are there in the Constitution. I think we should carry this book all the time because for lawyers, this is the Gita, this is the Bible, this is the Quran, this is everything for us. And all the authority that we draw is from this book, the Constitution of India. Because this Constitution is given by we the people. And when we say we the people, it is freedom for the people. We have suffered a lot under the British rule. Therefore, we want our freedom. We want our freedom of speech and expression. We want equality. We don't want to be discriminated. We want to ensure that everybody is treated with human dignity. And that is what we decided in the preamble. If you see the preamble, you have to read the Constitution very, very carefully, not as some book, but as a part of a living organism. Because the Constitution can never be static, the principal told us. It is not a static document, it is not just some words written here, but we have to make it work. And it is this concept that we have to bear in mind as students of law always. I am a student of law, you will always be. Shri Lotlikar is a student of law. You should see his passion even today in the court of law when he argues the matters. And that passion for doing justice should never go away from us. The day it goes off, the day we feel that we are complete and I know everything, your whole progression as a student is lost. So till the end of the day, we are students of law, please bear in mind this. Now, when we see the Constitution of India, there are so many articles, there are so many parts, then there are schedules. All the authority drawn by all the authority is from the Constitution. Now therefore, the Parliament, what is the Parliament? Parliament, they are just our elected representative. What is the Judiciary? Judiciary is something that is appointed by the Parliament. Then what is an executive? Again under the Constitution, we have municipalities, we have corporations. At the village level where there is decentralization of powers, we have the Gram Sabhas, we have the Gram Panchayats, we have the Zilla Parishads. So that's all about decentralization of powers. Why? Because the power should ultimately go to the people. So that is what it is. Now with all this, with the Constitution is ours, the government is ours, I really fail to understand why do we beg for anything. Why do we beg for something that is right? The courts probably follow the old British systems. Therefore this begging and all, when they come before the court, pleadings always are most respectfully show it, or I beg for this. Why should you pray for a relief? Well, that's your right. If you have a right, take it. If you don't, it's all right, the case is dismissed. But no need to beg for anything. Because that is what the Constitution says. We are not in the British era now. But that's how the system is working. It will take some time to change. It's changing, but it will change. Now therefore, so far as the working of the Constitution is concerned, you will find that when the Supreme Court, it's been 75 years for the Supreme Court, when the judges of the Supreme Court then our first Chief Justice, Justice Kanya, when he took over with some of his colleague judges, there were hardly any case laws assisting him. But they had to think. They were thinkers. They were good readers. And ultimately, they laid down the law which set the tone for the next 100 years at least. If you see the judgments of the first 10 years of the Supreme Court, you will have a complete, you will know what kind of vision the judges then had. And that holds good even today. Of course, the amendments are there to the Constitution. Several amendments have been made because you have to make the Constitution workable. You cannot change the basic structure of the Constitution because you are under the Constitution. And once the authority is conferred by the Constitution, You cannot change the constitution at all. That is what the doctrine of basic structure, someday maybe you can ask Shri Lotlikar to talk about the basic structure. It's a very important thing you must bear in mind. The basic character cannot change. So with this, I'll proceed further. As the Constitution of India and the interpretation progressed, things started changing. You know, it was not limited to deciding cases between two parties, lists between two parties, but state actions were under challenge. The state actions were challenged because the states have to abide by the authority conferred by the Constitution. And then comes the interpretation of Article 14, what is discrimination. Everybody started coming to the court, asserting their rights. And then as the Constitution and as the law expanded, not many things stated in the Constitution started being written in the judgment. And there is something called as silences of the Constitution, which we must all know. What is the silences of the Constitution? Silences of the Constitution really is a concept where something you won't find in the Constitution. Article 14 for that matter, just one line clause, but how much has been written on it? So as you see the facts and as you apply the aspirations of the people, understand the aspirations of the people, as you apply the law, you try to hear what the Constitution is telling you. And something that is not written in the Constitution, you put it as a judgment. And those are the silences of the Constitution which you try to hear and try to find out. A good example of the silences of the Constitution is the judgment in the judges' case. Now the power to appoint Supreme Court judges, High Court judges rests with the President of India in consultation with the Chief Justice of India. A simple article. So the power really is with the government. But then something happened, the things were not moving properly, they heard the silences of the Constitution, they heard the voices, and ultimately comes the judge's case, where they say this consultation really is the Chief Justice of India who will initiate it, and you have to just see whether the character of the person, the executive really has a very limited role to play. Leave the independence of the judiciary intact. We want to be independent. Please don't interfere with all this if you want us to work for justice. So these are the silences which has been put in those judgments. Then there is another angle where we have developed is legislation by the judiciary. Can the judges legislate? Because legislation really is the domain of the parliament. So therefore, we cannot enter their turf. The war always is, you don't enter my turf, I won't enter your turf. So this separation of powers, the legislative, executive and the judiciary, the three wings, have to be completely separate. And this is where the interpretation of the Constitution really assumes significance. Now this separation of power is something, the moment you try to enter the turf of somebody, and here I'll give you the classic example which we often hear, but we have to imbibe this as a principle, is the famous incident of Ramayana, where Ramayana all started. Well, Ma Sita was fascinated by a golden deer, and she asked Ram that, I want this golden deer. So he said, please don't be obsessed by materialistic things. It's just a golden deer. Well, we have everything with us. We may be in exile, but we should be happy. He said, no, nothing doing. I want the golden deer. So Ram obediently goes behind the golden deer. And then, of course, demonic forces, they spring up. Then suddenly, Ma Sita tells Lakshman, that who's there to guard her, that please go, Prabhu Ram is in some difficulty. So Lakshman says, no, he's a man full of valor. You don't have to worry about it. He'll come back. No, she says, I heard his cries. He needs help. So Lakshman has to obey what she says. But then Lakshman says, I'll draw a line around this hut. And this is the Lakshman Resha you shouldn't cross. And this we have been hearing very long now. That what is this Lakshman Resha? Well, that is Ramayana. Even today, the Lakshman Resha is drawn by the Constitution of India. Well, the Lakshman Resha really is whatever the parliament does is supreme, whatever the judiciary does is to interpret the laws. It's not the role of the judiciary to legislate. But has the judiciary legislated really? Have we thought about it? Do judges legislate? And I think the classic case of legislation is the Vishakha judgment. Vishakha judgment was the one where there was a complete vacuum. The women were troubled at, they were not treated well at workplaces, and therefore something had to be done. Supreme Court hears this is something which we have to do. Maybe till the time the legislation comes, we'll frame certain guidelines as to how these workplaces have to treat women. The women have to be treated with dignity. and therefore comes the Vishaka judgment. That is nothing but a judicial legislation. Till the law is enacted, then after the law came, where the women were protected, some inquiry committee set up pursuant to the Vishaka judgment. So this is the proactive role that has to be played by the judiciary. It is expected of the judiciary. Wherever there is a vacuum, and this is what 75 years of our the existence of the Constitution has taught us. Law evolves, things change. Then in the Constitution of India, not many things I can say, but few of the things I would like to say is Article 21, which is a very, very valuable right we have. You know, right of a personal liberty. What is a personal liberty? Nobody can take away that right from us. Then Article 20 we have. You know, nobody can be vexed twice for the same cause of action. Now the classic example, which is of course in a dramatized form, is the film, if you have seen. In our times we have seen that film, Andha Kanun. I don't know how many of you have seen that film. It was a very dramatized version of what this double jeopardy is. But that Mr. Amitabh Bachchan, who was the actor in that film, you know, is framed for a murder of one politician. Now he's tried. Now there are evidences against him. Naturally, the politician is very powerful. The accused is sent to the gallows, and then after he serves his life imprisonment, he comes out and finds that this politician is alive and he's grown big now. So he goes after him and kills him, and then again he's tried. So that there is the principle. He says, I can't be vexed twice for the same cause of action. I have already suffered for this. So this is more of a dramatized version, but this is what this concept is all about. Then there are some cases where this right of personal liberty, you know, right to a fair trial, where there is this concept of bail come from. Bail is a jurisprudence which has evolved over a period of time, a very important one. I have not done much of criminal law. I could do criminal law only as a judge. But the concept of bail, as was described by the great judge, Justice Krishna Iyer, it's bail, not jail. Why is this? Why should you have a criminal who is accused, staying right next to you while he is on bail? But this is a balance which has to be struck between a personal liberty, the interests of the society. This is a very, very vexed question. And even when we grant bail, we spend some sleepless nights whether I have done something which is correct or not. But it is the constitutional morality for us that matters. And even as lawyers, for you what will matter is not the morality which we practice at home, but for all the lawyers, judges, it's the constitutional morality that matters. This is the heart and soul of everything. We should not be too worried about what our personal opinions are. What will the society think of us? My daughter questions me sometimes, how would you grant bail to this mother who has killed her son? Just a newborn baby has been killed by the mother, flung off from the 7th floor, and you have granted her bail. How could you be so heartless? So these are the questions asked at home. But we do grant bail. Now, let me put to you the facts of that case. These are some cases which really, are hard-hitting. Now, here is this lady who is accused of, killing her child. The newborn is flung off from the 7th floor. So, if you look at these facts, it's a this mother is a wretched mother. But then, the materials on the record show that her husband had left her. She had nowhere to go. She was given some shelter by somebody, took her, and then, for a lady who has nothing, the kind of problems that she faces. And then she thought she was completely depressed, and she told some of the persons that I want to end my life, and I want to end the life of this child also. I can't take care of this child. I don't know if it is a baby girl, I don't know what will happen to her if I can't take care of her. She was really concerned for the child. And at the time of delivery, she doesn't go to the doctor. She goes to the washroom. And she was the one who cut the umbilical cord with the scissors. She does it. And the baby is delivered. Look at the pain that she has suffered. And the moment it is delivered, she flings it off from the 7th floor, saying that let it end its life. And then she is 1 year in jail. And I thought maybe the trial will proceed. Whatever it is, right, wrong, I granted bail. These are some things, which are very disturbing. But that is what a concept of a fair trial is. Bail is not something of, declaring that she is guilty. Bail is something, yes, you face the trial, but your personal liberty is important. If you are held guilty, you will suffer the conviction. There was another case I must tell you, which always troubles me whether I have given an acquittal correct or not, is of one lady. Well, this is a family, and I think we are all students of law. There's no question of scandalizing anybody or anyone. But you know, there's this lovely family staying in a city. Now, this lady has a son who is in the 7th standard. Now, the husband goes out for work early in the morning, comes back late. For whatever reasons, you know, she develops a friendship with a neighbor. Then it turns into an affair, and then it's taken too far. And one fine day, both of them, along with the child, go for a picnic when the husband is not there. And you know, the son finds something wrong with this relationship, and therefore he passes a comment and starts running away from the garden. So the moment he does that, they thought, okay, our game is up. And in that moment, this accused, he takes a stone and clobbers the child to death. Now, a son who is in the 7th standard clobbered to death. There was nobody around. Now, the mother faints seeing all this. When she recovers, she is in the hospital, and that time she gives a statement that this is what he has done. Now, because of this, naturally, her husband is very upset. It had to lead to a divorce. Then her parents were very upset with what she had done. And therefore, the parents say, now you fend for yourself. Please, you have given us a very bad name in the society. The parents are not there for her. She is all alone. The accused is in the jail. This lady is all alone. And when the trial comes, you know, the accused tells her that I am the only one for you. We are there for each other now. And then when the case goes for trial, this lady says, well, the accused was always with me. The son had gone for stroll, and there were some persons, and I don't know what has happened really. This is the evidence in the court. The trial court convicted her and convicted him, and rightly so. But we have to go by the evidence. There was no evidence, and this could hardly be an evidence. But the mother has completely changed her testimony. Reluctantly, well, I have written that judgment, but we had to acquit that gentleman. Now, the question I put to you as students of law is, who is really to blame for all this? Is it the mother? Is it the accused who instigated her, induced her? Is it the husband who was going out for long hours? Maybe he didn't look after the family. What is it? Who is really to blame for all this? Is it the parents who did not care for the daughter? How do we look at it? As lawyers, we have to look at it from different angles. It can't be just one angle. We have to give different dimensions to these cases. And I personally feel it is for this reason why this institution of marriage is, we have some set foundations. When we take the marital vows or whatever, this is how the Indian society is. It may be a regressive thought. We are quite open now. But that therefore this, Lakshman Resha, even in institution of marriage, this Lakshman Resha has to be there everywhere. And it is for this reason, by experiences, some principles are drawn up. Then again, as students of law, I'll put to you one more thing. That the case of Sabarimala, very interesting case, where the right of women is the right of women to enter the temple. You know, the tenet is for times immemorial, it has come that they cannot enter the shrine. That is what the facts are, I guess. So, the right of women, to what extent do we take it? Are we going to interfere in religious affairs? Should we do it? The Constitution says yes, there should be no discrimination. So, this is something, a lot of thought has to go into it as we progress. Well, there are some answers which I really don't have. Let us see how it develops. Right now, there is a judgment of the Supreme Court. But as things change, the live-in relationship is something much talked about nowadays. Whether we should accept it, not accept it. Times are changing, things are changing. The much is now in your hands. And this is what I'll be, putting across, that as students of law, please, whatever happens, it is the constitutional morality that we have to bear in mind. Our personal opinions aside, but the Constitution, what it says, and that is how you'll find that the judgments of the judges are criticized, not because they are their personal opinions, but it is because they have to lay down some principles of the Constitution. With this, there are many things I can speak about. We can go on and go on. Article 14 is something which has been expanded right from the time when the Constitution came 75 years ago till today. You will find judgments and judgments where they have expanded the scope of Article 14, discrimination. Then with fundamental rights comes fundamental duties. Even the duties are very important. We only ask for our rights, but what about our duties? That is something we should also be concerned about. Those are basic courtesies, I guess. So with all this, I think I should be ending this session. Well, it's been a real pleasure. All of you are listening so intently, carefully. But thank you so much and wish you a happy Republic Day in advance. Thank you, analysts. Thank you, sir, for coming. It's an honor. And I thank the principal, this beautiful college. Thank you so much. God bless.
Thank you, Your Lordship. Listening to the valuable insights of the judge of a constitutional court is not an everyday opportunity for us law students who are just embarking the legal ship. It was a remarkable and enriching experience for all of us present over here. And I'm sure Your Lordship's words will continue to resonate with us long after this occasion. I would now request our principal, Dr. Shabir Ali, to present our chief guest with a memento as a token of our utmost appreciation and gratitude. We now take a brief moment to announce the winners of the All Goa Digital Poster Making Contest organized by the NSS unit and the Center for Political Leadership of V.M. Salgaocar College of Law in collaboration with the Directorate of Higher Education, Government of Goa, to commemorate 75 years of the Indian Constitution. I request our principal, Dr. Shabir Ali, to hand over the cash prize and certificates to our winners. In the first place, we have Ms. Poonam R. Prabhu-Desai from Shri College of Commerce and Management Studies. I would now request our chief guest to hand over the second prize to Ms. Eugenia Meloi Granjo from V.M. Salgaocar College of Law. The posters of these winning students have been displayed outside hall number 10. I would now request our faculty members and dignitaries present here to kindly proceed to the stage so that we could take a photograph to commemorate the occasion.
Judge, High Court of Bombay, Goa, Principal Dr. Shabir Ali, Dr. Amol Shirali, distinguished members from the bar, the senior counsels, members from Professor Carmo's family, colleagues and students. I think today is a very beautiful day because we have assembled here to cherish the high ideals of the most valuable document for all of us, the Constitution of India, and also to release the book that we had published in memory of late Professor Dr. Carmo D'Souza. And I'm extremely happy and fortunate to propose the vote of thanks for an occasion such as this. On behalf of the management, principal, staff and students of V.M. Salgaocar College of Law, I express my deepest gratitude to our chief guest of the day, Justice Karnik, sir. Thank you very much, sir, that you have very graciously. Thank you, sir, for graciously accepting our invite and addressing us on the role of judiciary in a democracy. Sir, it's not every day that students, all of us students of law, get to hear from legal luminaries that are occupying constitutional positions. We only read about constitutional codes and constitutional positions, so we are extremely happy and we are delighted, sir, to listen to you from, and heartfelt way I'm saying this, because we assure you, sir, that we would all keep our ears and minds and souls and our hearts open to listen to the silences of the Constitution which Sir has enlightened us about, and also to go by constitutional morality and long-lived Constitution and constitutionalism. I thank you very much, sir, once again. And sir, we haven't heard you enough, so we wish that you would come again to our college and we could have more in course of time to come. I would like to express my gratitude to the Directorate of Higher Education, Government of Goa, for sponsoring this program. And I thank Lotlikar sir and Bharne sir for being here. It makes a difference for us. Special thanks once again to members of Professor Carmo's family members. And I would like to express my gratitude to our management for their continuing support in all our endeavors. And to our principal, Dr. Shabir Ali, for his constant encouragement and guidance. Thank you, Shabir sir. I wish to thank our administrator, D.P. Pednekar, and staff for the logistic support. Thank you, sir. Thanks to all our faculty members and students for being here today. Special thanks to Annalise Fernandez for coordinating the invite and making it so easy for us. And I must thank Mrunmayi, thank you so much for introducing the book and for the release, and also for editing the book. And I must thank Dr. Amod Shirali for his able support and meticulous planning of the program. And I thank my students, Bhumika, who was a compare, very well, Bhumika and Arya, for all the support, and also the student volunteers who are behind the screen. Eugenie, of course, for designing this beautiful, elegant banner for us, and also Adar, Sushmita, and Himanshu, who are there behind the screen. Thank you, one and all. Once again, long live our Constitution, Jai Constitution. Requesting everyone to kindly rise for national anthem.